having the difficult decision with yourself, your family, and your staff about whether bankruptcy and winding your business down is right for you during these difficult times. Today on the podcast.
This is the Wedding Industry Law Podcast, a podcast dedicated to wedding professionals that are just trying to keep it legal. And now, your host, Rob Shank.
Hey out there, welcome back to the podcast. My name is Rob. We are going to be talking this week with Will Geer, who is a bankruptcy attorney in Atlanta, Georgia, very knowledgeable about the financial situations of people and businesses who may view bankruptcy as an option for them. So I'm extremely sensitive to the fact that we as an industry, we as a community, the wedding industry, that is, we're sticking together. We're keeping our nose to the grindstone. We're working hard to get through this, and I'm hoping, and I'm everybody is successful at that, and everybody comes through at the end of the day. There will be some of us, though, that won't be able to weather it. And I want this particular episode to be a resource for you. I'm not trying to be a gray cloud. I'm not trying to ruin your day. I just want to put resources out there for the people that might be thinking to themselves, what are my next steps if I can't make the next mortgage? I can't make my commercial lease for the next 2 or 3 months. What are my options, and who can I turn to? And I want you to be able to turn this episode. So again, we're going to have actually, I think, our first guest ever on the podcast. His name is Will Geer. He's an attorney out here in Atlanta, Georgia with me, not with me, but with me in the sense of we're both in Atlanta, but he specializes in bankruptcy with Wiggum and Geer. Great guy. I've known him for almost a decade. So cool guy. Again, I apologize about the audio quality. My system had a system malfunction right before I called him. So this, I think, was just through telephone. So if you're watching it on YouTube, it's going to be a static image. If you're just listening to this, like Spotify or Apple Podcasts or whatever, the quality might be not great, but I would also keep you, or remind you that at the end of the episode, we get into, the aspect of whether there are criminal or civil ramifications for taking money from clients if you are on the fence or you know that you're not going to continue as a company. So there are those implications, and we do get into that a little bit at the end of the episode. So if that's something that you're interested in, stick around for the full conversation. But otherwise, we brush on what bankruptcy is, when it may or may not be beneficial for somebody, and what are the ramifications. So without further ado, let's get into that conversation with Will. So Will, a lot of my listeners are wedding industry professionals. They're small business owners. They have employees. They've got, accounts payable, accounts receivable, and obviously with the coronavirus, it's a possibility that they could be in trouble. So can you lay out from a 40,000 foot view what personal bankruptcy options there are, what company bankruptcies options are, and maybe what the differences are for those?
Yeah, sure, Rob. I don't mind doing that. So as far as a business is concerned, I really like on a lot of these wedding venues, I imagine that we're talking about small companies, Rob. Is that right?
Yes. And when we say small, it's not within it's not like 500 employees or less. We're talking probably 10 employees or less.
Yeah. That does help me out as far as this is concerned. So most of the time in these businesses that size, you're going to be personally guaranteeing any kind of loan you have with the company, any kind of credit card that the company has a name on it. Your name's probably on it too, which also means that you're liable on that credit card. Some vendors may even make you wind up personally guaranteeing the trade debt that your company has. And of course, if you have a leased premises, you probably are guaranteed on that as well. And look, if you're in the position to where you contact a bankruptcy attorney and they tell you, look, I don't think your business is going to survive, you need to file personal bankruptcy, there's a few options for you. There's a Chapter 7, which is, they call it a liquidation bankruptcy. In reality, almost no one loses any property in a Chapter 7 because unless you have a ton of equity in your house or you have a bunch of stocks and bonds and a bunch of cash lying around, you're probably not going to lose any property in a Chapter 7 because under Georgia law and federal law, you could take certain exemptions in all of your property and protect it from the reach of your creditors. So that's one way you can go, and that's kind of what we call the quick and dirty bankruptcy. You're done in 4 months, all your debts are discharged, you can start fresh. You got another one for individuals too, called a Chapter 13. They call it a wage earners reorganization, which really means you need a job of some kind. And obviously, if your only source of income is through the business that is being shut down, that may not be possible for you. But if you have a spouse that is making significant income, you may have to file a 13 anyways. So through that, you're going to be paying back a portion of your debts over time through a court-sponsored repayment program. It can last 3 to 5 years. You're only going to afford you're only going to pay what you can afford. And at the end of that payment plan, everything else is discharged. It's all wiped out. Chapter 13 is really good. Like, if you have a bunch of tax debt, like, look, if you got in trouble and didn't pay some priority, like some FICA taxes on your employees or something, you can kind of throw that in there and pay that off over 5 years with no interest, right? So that's a good way to take care of that kind of debt. The last chapter I'm going to talk about is a Chapter 11. There is a new Chapter 11 called the Subchapter 5, Chapter 11, that is specifically for very small businesses. And because of the coronavirus, actually, Congress has upped the limit of debt. So it used to be approximately $2 million. I can't quite remember the exact number, but let's just call it around $2 million. If you had more than $2 million in debt, you could not file under this new Subchapter 5 bankruptcy. Now, if you have $7 million of debt, you can file as a small business, which obviously puts a ton of people and a ton of small businesses in that purview. Now, most of these businesses, like winning businesses, I would imagine probably wouldn't have even $2 million of debt. But if you did want to make a go at it and you wanted to keep your business, you could file under Subchapter 5. It's a little more expensive though. It's, you're talking about anywhere from $15,000 to $20,000 to pay your attorney to file a Subchapter 5 bankruptcy. But you could pay back some of your creditors. You could continue to operate, and as long as you had cash flow, you could pay back maybe only a portion of some of your debts. So that is a viable option. I could go on and on about it, Rob. But effectively, those are the three chapters and options you're really going to have.
Okay, so let's say that you are a DJ or a photographer, you're a planner, and you're not going to be able to pay your rent. You're not going to be able to pay your mortgage. You've fallen behind. At what point should somebody start thinking about bankruptcy as a form of financial protection for themselves? What's the cost benefit analysis that somebody should in their head go through before they would call a bankruptcy attorney?
That's a tough question to answer, actually, because it's going to be different for everyone. And so here's the generalized answer. You should call someone as soon as you think you have a financial problem. Because one of the things that all of my colleagues will tell you, I will tell you is, man, I wish you had called me 4 months ago. Because you want to get out ahead of the problem, even if it's too early. Because, look, our job is to analyze your situation to see, is bankruptcy right for you? And if it's not, we will not put you in a bankruptcy if you do not need to be in one. Hey, you can only do a Chapter 7, for instance, once every 8 years. That's a big deal. And two, it does affect your credit to an extent. It's not as bad as people think it does, but it does affect it. So if you can avoid bankruptcy, it's advisable. If you have some other way to, like, if you only have $5 or $10 grand of debt, you're probably not filing bankruptcy unless you just have no other recourse. But if you start racking up 25, 30, 35 grand of credit card debt, especially at 20% interest, I mean, if you don't have an income, you're not going to pay that off. So as soon as you start missing payments, I think it would be advisable to at least call a bankruptcy attorney and say, hey, what are my options? Who should I prioritize payments to? And questions like that, but anyone worth their salt is going to give you, they'll give you 15 minutes of their day to talk to you about it.
Right. So I guess if I understand you correctly, there's kind of like a checklist or a hierarchy of questions that you would go through from your standpoint of whether or not bankruptcy is right from somebody from a legal standpoint, but then also from a business standpoint. So if you're saying that, if you've got, less than 20 grand of credit and, the economy might turn around, then no, it might not be right for you. But, you have a list of questions that go beyond that. It's like, okay, this is, start thinking about this. So what are some of those things?
Well, yeah, like, look, if you got a ton of equity in your house, Rob, like if you tell me like, hey, Rob Shank is a wedding photographer all of a sudden. He decided, tomorrow, just wasn't doing it for you.
Right.
You want to be a wedding photographer.
Okay.
But hey, look, I got a house and I got $300,000 of equity in my house, man. Well, I want to tell you, Rob, Chapter 7's not right for you. You're going to lose your house unless you're okay with that. Unless you just have no other option, you're going to also get foreclosed on, in the next 5 days. Well, you'd rather at least get a little bit of money out of it than no money.
Mm-hmm.
Right. So these are the kind of in-depth questions we would be asking, our clients or our potential clients to see, all right, is this right for you or not? Just because you're going to lose an asset doesn't mean you shouldn't file bankruptcy. It all depends on where your income is going in the future and what you can afford now. Because again, if you were in that situation we just mentioned, I wouldn't want to lose $300,000 of equity either in my house. But look, if you have no other option but to have someone help you file bankruptcy, and you at least maybe get $40,000 of it, if you're married, for instance, or $43,000 to be exact, then you'd rather have $43,000 than no dollars from the sale of that property, right?
I gotcha. So
yeah,
if I understand you correctly, if someone thinks they're getting into trouble, definitely if they foresee themselves getting into substantial trouble, that it would behoove them to talk to a bankruptcy attorney or a CPA or somebody that can guide them in the right direction.
Absolutely. I would say go ahead and talk to a bankruptcy attorney, frankly, because you're going to find that, look, all of my colleagues are good people. I can't name a single bad person in the bankruptcy field, frankly, who does better work. So they're probably going to give you the time of day if they have time to talk to you, and they're going to help you out. They're going to give you a free consultation. We give free consultations, and we're happy to go through this process with people. And look, I mean, if a wedding planning business or a photographer or DJ called and said, hey, my business, DJ Unlimited LLC, if we have $20,000 in credit card debt, well, we're not filing a Chapter 11 for you because it costs $20,000, right? I'm just talking about and I'm maybe getting in the weeds a little bit, Rob, but the point is that person though, maybe they can't pay their mortgage or maybe they can't pay their rent and they want just questions like, hey, what do I focus my payments on? And is bankruptcy even right for me right now? Yeah, we're happy to answer those questions, right? And look, if you got at least $20,000 of credit card debt and you don't have much of an income to speak of, you should probably be looking at a bankruptcy.
I guess I never thought of it though. So you're kind of like a Dave Ramsey kind of situation going on, not just counselor at law, but I guess counselor of the wallet. That makes sense. So, okay.
You say that. We'll ignore the Dave Ramsey analysis, but yeah.
Yeah. Okay. So you mentioned, I wish some people had called me 4 months ago. If it's possible, can you give me one or two examples of a situation in which what's something that you can give to somebody right now, that they could use right now and call you versus in 4 months from now? What is one of those examples?
All right. Someone gets sued and they decide they're just going to ignore the lawsuit, or, I got an official letter I got served a summons by a sheriff, right? And they just put their head in the sand, and then they wait 4 months later until they got garnished, and then they want to hire a bankruptcy attorney. Well, now that person may have no money in their bank account to even hire a bankruptcy attorney, and they can't even file a bankruptcy. Right. So, yeah, I wish you could have saved yourself a lot of heartache and headache if you'd have called someone 4 months ago, right when you got served with a lawsuit. Any attorney, they may say, hey, I can defend you, or, hey, I'll shoot you over the will if you can't afford to defend this, especially if it's like a credit card suit where there's not a lot of defenses a lot of times.
A suit on an account.
And you just file bankruptcy. Or a very bad situation that happens all the time is someone's house is going to be foreclosed on Tuesday of the first Tuesday of the month, and then they call someone Monday night at 9:00. Say, hey, can you stop this foreclosure that's happening tomorrow? And most of the time, the answer is going to be no. I need, you got to pay your bankruptcy attorney. You got to go take a credit counseling course. You need a few days to prep. So the general lesson here is, if you think you're in any kind of financial trouble like this, you need to go ahead and call someone to at least get a preliminary analysis of what's going on.
I gotcha. So, and I guess we started a couple of questions ahead. So can you kind of, from a 40,000 foot view, can you explain what bankruptcy is? What's the process? What's the goal of bankruptcy, and what can you expect after bankruptcy?
Yeah, that's a good question. A lot of times we attorneys think people know things that we just take for granted.
Right.
So yeah, I'm happy to do that. Yeah, it's a bankruptcy is just a set of federal laws that allow you to wipe out debt from prior to the day that you filed the bankruptcy. And it's very simple. So bankruptcy allows you to wipe out all of your credit card debt. You can wipe out generally almost anything, even certain taxes. Like if your income taxes are more than 3 years old, you can wipe out income taxes. A little more complicated with caveat on that than that. But the point is you can wipe out almost any type of debt, really. Now, there are certain types of debts that are not able to be wiped out in a bankruptcy. Everyone's favorite example, student loans. It's very, very difficult. I shouldn't say you can't wipe them out, but let's just say you better be blind and disabled or something, or you're not passing the test, right?
Right.
But other than that, yeah, any kind of business guarantee, and I get this question a lot, Rob. People think that SBA loans can be discharged in bankruptcy for some reason. I don't know where that myth came from. You can absolutely wipe out an SBA loan in a bankruptcy.
Okay.
There is no priority for any kind of SBA or anything like that, any kind of SBA loan or USDA loan or whatever.
Okay.
Just because it's backed by the government doesn't make any difference. So yeah, I mean that's bankruptcy in a nutshell. It's a vehicle to allow you to wipe out all of your debt and get a fresh start.
Okay, and so that makes sense. So there's a bucket of debt that gets wiped out, meaning that you will not owe it any longer. And we'll talk about this in a few minutes, but there'll be a bucket of debts that you cannot extinguish, which I think you said student loans is going to be in that bucket.
Yes.
But what's the ramification of that? I mean, like, why can't I just do that right now? Because it sounds awesome. Like what's, as far as the cost benefit goes, why aren't everybody doing this every day?
Why isn't everyone just filing bankruptcy every day?
Yeah, like if I can just pay you money and you get rid of all my debt, why wouldn't I just go ahead and do that right now and then start another business tomorrow?
Well, for one, it does hurt your credit for a couple of years. I mean, you're going to have a credit problem for at least 2 years. You're going to be able to get another credit card, but with severe limitations, like maybe only $1,000 credit limit. But again, you can only file a Chapter 7 once every 8 years. And a Chapter 13, if you've ever done one, which I know you haven't, but no one wants to be in a 13. All right, it's 5 years where you're literally in bankruptcy court for 5 years making a payment plan. It's not like you're just like one and done like a Chapter 7. So Chapter 7, look, I've seen people file bankruptcy for $5,000 of credit card debt and really wish they hadn't. And I would advise that person, hey, look, you only got $5,000 of debt. You just need to pay your credit card. Like, figure it out. You know, go hustle, go do whatever you need to do. Go do what you need to do.
Donate plasma.
$5,000 of debt.
Yeah.
Donate some plasma. Do whatever you got to do. Find a side hustle, find a side job. But once you start getting up into, the 20 to 25 range, and, it all depends on your income, Rob. If you're making $100,000 a year, I would tell that person, hey, look, you're probably not going to qualify for bankruptcy anyways. Because there are income limits, by the way, for a Chapter 7. Like, if you make $100,000 of income and you're not married and you live alone, you're not taking care of any dependents.
Sounds awesome.
You're not filing a Chapter. Yeah, you're not. You're not filing Chapter 7. Okay.
I gotcha. Okay, so if I understand correctly, then then the ramifications are your credit is hurt. You can only do a 7 once every 7 or 8 years, but other than that,
other than that, yeah. I mean,
okay.
That's a big other than that.
I mean, there's probably a lot of people out there right now that I don't know, that maybe not have credit cards. So they don't care what their credit score is. But okay, let's.
If you have equity in your house, also, you're not. A lot of people don't want to lose some assets. I mean, you
Sure.
may have, especially elderly people. Like that's a problem in Georgia. You may be 65 years old and have $150,000 of equity in your house, but you racked up a ton of credit card debt because you lost your job.
Exactly.
And you don't have sufficient retirement. So it's, in California, for instance, they have much larger protections out there for elderly people who have equity in their homes. We don't have that here. So you got to take all this stuff and really figure out, is bankruptcy right for you? So to your point, like the cost benefit analysis, I would say that, look, you file bankruptcy, you're not buying a house for at least 2 years. You may not be able to buy a car without a co-signer for a couple years. And generally, I just find that people they don't really want to file bankruptcy, right? Like if you got to pay me $2,000, let's just call it a $2,000 bankruptcy fee, you got to make it worth it. So, I mean, yeah, if you got $20,000 in debt, that's worth it. But if you only got $10,000 in debt, I mean, most people would just rather try to figure it out. And
right.
I would agree with that, especially if you're employed.
Okay. So we've talked about what bankruptcy is, why you would do it, the pros and cons of it. We talked about for a second, we've talked about the bucket of debt that can get wiped out. We've talked about the other bucket of debt that cannot be wiped out with bankruptcy, and that includes student loans, and I think some
recent taxes.
Yeah. So and those things are variable, as Will mentioned. Okay, I want to talk about this now. At least maybe 6 or 7 years ago, there was a venue owner, I think based out of New York City, and he, and from what I can understand, because there were criminal and civil proceedings against this guy, and what was going on was that he continued to take in money as a wedding venue operator from clients up until the day that he walked up and put a padlock on the door and closed down because he had no money. Okay. So can you address, and again, that's why I keep saying this bucket. In the bucket, money or debts that are debts through fraud and lawsuit judgments that are fraud judgments are not dischargeable under bankruptcy. So if somebody can prove that you got money illicitly, you can't put that in the bucket of dischargeable debt. So can you kind of walk us through that process, like a little bit?
Yeah. So the description that you just gave of that company and the guy, I imagine like if he were to file personal bankruptcy, but he was taking money and deposits from people and knowing, now this is the key part, he knew that he wasn't going to be able to provide that venue or that service to these people, but he still took their money. Yeah, I think they could win in a fraud. They would have to come into bankruptcy court. They'd have to sue him in bankruptcy court and say, hey, judge, very simplistically, but you'd want to hire a lawyer if you were the other party of this, but you'd draft a complaint and say, judge, I don't think this should be discharged because XYZ, and your XYZ is he took deposits, he wasn't going to provide the service to me, so basically he defrauded me out of my money. That's not dischargeable. You can't get rid of that debt. So any debt incurred through fraud is not dischargeable. Now, if the guy was just taking deposits and trying to make a go at it and paying his rent and paying his mortgage and paying his employees, and just one day like he just got kicked out, that's a little different. That's your classic robbing Peter to pay Paul. Where look, it's every business that goes bankrupt, right? That doesn't mean there's any fraud behind it. It just means that he just got overwhelmed. But now, again, to your point, if he purposely took people's money, kept it, knowing he was never going to be able to deliver on the final product, I think you may have a fraud claim there, and he's not going to be able to wipe that out.
So,
but you got to file something, Rob.
Yeah, you got to file
something with the court.
Exactly.
Yeah.
So, okay. So for anybody out there listening right now, I only bring this up because I get asked this question, and most of the time the question comes to me from the actual couples that are trying to get their money back. Like, well, they can't do this. Like, that's fraud or whatever. It's not fraud to go out of business. It's not fraud to have the hope and desire that your company survives so you can make a livelihood or you can make a living. So I guess there is a kind of like a gray area where if you are continuing to take couples' money and you are not certain that your company can continue as a going concern, there is a possibility that fraud charges could be brought up against you. Not fraud in the criminal sense, but fraud in the civil sense. A fraud lawsuit could be brought against you. Now, Will, what are some things that the business owner in that situation where you're quote unquote robbing Peter to pay Paul, that somebody can do to stay above the line of I'm making a go at this. I hope, and my goal is to stay in business. My goal is not to take this money and shut it down. What's some evidence, or what are some things that people can do to help take them over that line of I'm not committing fraud by accepting this money, even though I'm not 100% certain I'm going to be open in 4 months?
I'll tell you, if you're thinking like that, you may just not want to accept any money at that point. If you're already thinking like, well, I don't even know if I'm going to be able to provide this. It's kind of a hope and a prayer, right? I think you better be very careful if you're the business owner on accepting people's deposits. There's also a morality. And look, I know this is not an ethics podcast, but at the end of the day,
if it's involving me, it is not an ethics podcast. If I'm involved,
not with Rob Shank on the line.
Yeah.
So, is your mom listening?
Mom is the only one that does listen.
Mom is the only one.
Yeah.
Yeah. Rob's mom. So look, if you are taking money and you intend, and again, it can't just be a hope and a prayer, but if you're like, look, if the landlord's not coming after you, if you think you got the venue, if everything's kind of good to go, yeah, I mean, you can make a go at it. And if something happens unexpected, but look, if you have, I can't, Rob, there's no like spectrum I can say, oh, well, you're 20% sure, 50% sure.
Right.
There's nothing like that. It's going to be very factually intensive, very factually intensive on something like that. But look, if you have to ask yourself the question, it's kind of like, look, am I too drunk to drive? If you got to ask the question, you probably need to call a cab.
Right.
So in this instance,
I feel you, but I here's kind of my 2 cents, but I'm not a bankruptcy attorney. I am a business law attorney though. I would say this, like if obviously you can't do what Will has said, which is bury your head in the sand. So hopefully as a business, you have cash flow projections. You have projections of your finances going 6 months, a year ahead or whatever. If all signs point to September, you're going under no matter what you do, then you're probably below the line, and it's possible that it's more likely that you'd be committing fraud if you took money. However, if it looks like if things happen as they're supposed to happen, or, with a little bit of luck, this can happen or whatever, you're getting closer to the line of, okay, maybe I'll be, it's not necessarily a fraud allegation, I'll be skirting around.
Sure.
But again, neither Will nor I can definitively tell you anything, because there's no bright line rule. There's no statute that's like, oh, if you take money on this day, then, it doesn't work like that. It's just, It's just what can somebody prove in a court of law through your books, through your testimony, what you said in an email or whatever. And that all gets crunched into whatever somebody can convince a jury of. Or I don't even know how that works in bankruptcy court. Maybe you can tell me, Will, but whoever you're convincing.
I'll put it to you this way. This is again getting very factual, but if someone gave you a deposit in January and your wedding went until 8 months later and all of a sudden you went out of business, I don't think it's unreasonable to say that in January, as long as everything was going okay, you did what you could.
Right.
You may have already spent that deposit money on something, and that person's probably out of luck. Again, if you're taking money though, and you just got an eviction notice from your landlord, I think you should probably return the money. I would say this: if you have an inkling that like 3 months down the line you're not going to be able to perform the service that you're being paid to do, I think being fully transparent with the person and give them the option, which I know may hurt your business, but at the end of the day, you don't want a lawsuit. You don't want to deal with it. It's a lot more expensive to have to deal with it.
Right.
On the same token, it is expensive to hire someone to look. If you're owed $5 or $6 grand from someone who files bankrupt, like let's say you're on the other end though. Let's say you're the person who paid a deposit to a wedding business, and now they went under and you lost $5 grand. Are you going to hire an attorney to go fight over $5 grand? Frankly, probably not.
No.
It's not. So yeah, that'll be wiped out, because if someone came to me and said, hey, well, someone swindled me out of $5,000, I would say, well, my retainer's $5,000 for litigation. So, I mean, unless this is really about just principles, which I don't advise anyone to file a lawsuit based on principles, take it to Facebook or something. Write a review online.
That's an excellent point, and it's a point that I probably make at least once an episode, that typically it's never worth it to file a lawsuit against anybody for anything in the business context. But well, great. Well, I think that we've covered a lot of important stuff. I really appreciate you coming on and giving us your expertise, and maybe we'll get you on. Maybe do like a case study with that person out of New York, because I would love to pick your brain on the facts of that particular case of what happened. But at any rate,
yeah, man.
Awesome.
Happy to do it.
Awesome. Well, thanks so much, Will.
Take it easy, Rob.
All right. Again, thank you so much to Will for being a part of the podcast and providing us with much needed information. So, again, if you are enjoying the content of this podcast, please like and subscribe. Leave a comment if you have any suggestions for anything for me to talk about. And if you have any questions or concerns, that's how to do it. Or you can hit me up on Instagram. Either way, would love to get some feedback from you. And with that, we will see you next time.
Thank you for listening to the Wedding Industry Law Podcast. This podcast is intended for general information only. Nothing in this podcast is intended to be legal advice. Do not rely on this podcast for your legal matter. Instead, consult an attorney in your area. Thanks, obrigada, até semana que vem.